Hello and welcome to this third session on the ladder of discipline. My name's Michael Lockley, and in the third session we're going to be looking at the difference between negligence and conduct charges, as well as getting the wording right. If you did miss out on session 1 and 2 of the series, please look out for the videos on my YouTube channel, Lockley Consulting. They are independent of each other, but they do building blocks towards a formal process where you need to charge and actually present evidence in an inquiry. So in the first session, we comprehensively looked at the 3 types of warnings that may be issued to employees as a means of corrective action and addressing unwanted behavior. And in session 2, we looked at the process required to be followed to ensure that the issuing of those warnings was indeed fair and that a consultation process took place. In session 3, we're building on that and looking at the following: the difference between misconduct and negligence-related charges, the critical aspect of getting the wording of the charges correct, and finally ensuring the charges relate to what it is that you actually have reasonable chance of proving within the formal process. So what is misconduct and what is negligence? Firstly, misconduct and negligence are both misdemeanors and are both seen as misconduct, but there is an important difference. It is important to understand what it is you are trying to prove, and that will dictate whether it's a negligence-related or misconduct-related charge. Remember, one can be as serious as the other when it comes to negligence and misconduct, but the one really goes towards intent. An example of intent would be theft. There was intent to take the goods, they were not taken by chance or by accident, so the theft charge would clearly relate to misconduct. However, if a forklift driver causes damage to goods whilst on shift, could you prove intent to do so? Probably not. And in this instance, the charge would be negligence relating to damaging goods, not misconduct, although misconduct and negligence do go together, but it's important we understand the subtleties. Remember, negligence is not a Cinderella of misconduct. It can be as serious or more serious, especially relating to the damages that negligence may have caused the company. If we look at wording on charges, wording is critically important. Words must relate to the type of offence and provide detail of what is being charged for. An example is the misconduct theft charge referred to in the previous slide. Misconduct related to theft would not be a charge. It would simply be a title. However, misconduct relating to theft of 500 rands worth of tin beans on Monday, 8th March 2021 on day shift would be a comprehensive and proper charge. And using the forklift negligence example, negligence due to damage of goods would not be enough. However, negligence relating to the damage of 1,000 rands worth of company goods whilst driving your forklift on day shift on Monday, 9th of March 2021 is a better and more comprehensive charge. We need to ensure that charges are relevant. So many charges that I've experienced, especially when I've been asked to chair, and I chair on average 40 to 50 inquiries a year, they fall into the trap of using wrong terminology or using wrong type of misconduct given what evidence you actually have to prove. A classic one is charging for insubordination when all your evidence shows failure to carry out a reasonable instruction and doesn't and won't prove insubordination at all. Always seek advice if you are unsure from your HR department or your legal beagle. It's no good going through a whole process of preparing for and leading evidence in an inquiry, or at the CCMA for that matter, and your evidence does not relate to what you are charging an individual for. So your evidence can be very convincing, but it's convincing around the wrong charge. So a chairperson and the commissioner at the CCMA is not going to find you right because everything shows it was a failure to carry out a reasonable instruction, but you've actually charged for insubordination. The two don't go together. So you need to blame yourself, not the chair, if you lose your case due to incorrect formulation of the relevant charges. So finally, make sure the charges relate to the misconduct that you are able to prove. In summary, you need to understand the important difference between if you are able to prove intent or not, in terms of what you're trying to show in a formal process. Misconduct-related charges go towards intent, whilst negligent charges go towards just as serious a misdemeanor in most instances, but where you are not going to be able to show intent, just negligence. Negligence is not less serious than misconduct, but understanding the difference helps you to formulate correct wording for the charges and also helps you prepare your evidence accordingly. Also, make sure the charge relates to what you can reasonably prove, i.e. don't charge for insubordination if it was failure to carry out a reasonable instruction. This is not insubordination, it's negligence, unless you can prove intent. Then it would become insubordination. What to expect in Session 4? Session 4 will cover how to issue a notification for a formal inquiry, the rules relating to suspension with pay prior to a formal inquiry, and then the rights of an employee going into a formal inquiry. And these are extensive, and for the procedural fairness to be ensured, we need to ensure we dot all those I's and cross all those T's. Until next time, thank you very much for listening and going through the slides with me. If you have any queries or you need any further help, you're welcome to contact me. My email is on this final slide. And please remember, the content in this video is not a legal opinion. Always consult a legal practitioner as needed. Thanks for your time. Until the next session, keep well and stay safe.